Hi. Good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna PC. Uh, this is a community conference call. Well, supposed to be a conference call, but our conference call is down. I'll get to that in a minute. What I'm doing is I'm responding to all the questions that were posted on the in the forums for the conference call, and we'll have them available to you by this afternoon. Any follow-up questions, I think what I'll do is I'll open a forum in the same community conference call forum. I'll open a thread. You can put in your follow-up questions there, and I'll get to it. Once they have the conference call running, we can do maybe another conference call during the next week or so. Um, I want to remind you that this conference call does not mean that we are establishing an attorney-client relationship here. I'm just trying to answer the questions to the best of my knowledge and sharing information with you. Um, this is not a substitute for a one-on-one consultation, or merely an augmentation and hopefully showing you the direction that you need to go. Okay. That said, let's begin with the questions. First question is from Prit Vijay, who says, EAD status during employment change. They have a pending I-485 case for 5 years. Their EAD and AP is valid till 2015. They also have an I-130 petition filed by her husband, who's a US citizen. So the question is, if she quits her job, how long can she stay without a job? This requires a little more conversation. Let me explain to you how this works. First of all, the spouse of a US citizen who has entered US legally and then become out of status or unlawfully present, even for 20 years, they can get their green card within the United States without any problem as long as they don't travel outside USA. So if you even went out of status or were unlawfully present, that should not be a bar from you getting your green card. Okay? That's one concept, as long as you don't travel. Okay? The second concept you need to bear in mind is this. In order for you to file an I-485 normally, not as a spouse of a US citizen, normally, you have to be in status on the day you apply for I-485, like H-1 status. Here's another sub-concept here. For employment-based applicants, up to 180 days of out of status are forgiven, employment-based. Something to remember. Okay. So if we combine some of these things that we know and try to answer your questions, how long can I stay without a job? Indefinitely, because you are relying upon your family-based case. Does it impact your EAD status? No. Employment authorization document is a permission, not an obligation. It's a permission, not an obligation. What does that mean? If I have an EAD, I have the permission to work, but not an obligation to do so. If I want to sit at home and watch soap operas all day, that's perfectly okay. It's a little bit trickier when it comes to employment-based cases, but in a family-based case, definitely no problem. Can my employer revoke my status? What if they do? Doesn't matter. Don't travel, get your green card within the United States, you should be fine. If I find a new job, what documents do I need to file with the USCIS? Nothing, you just need your EAD. Okay. And do I need to inform my employer's lawyer? I'm not sure what that means, but definitely there are two components to a lawyer's representation. When we take on an employment-based case, some part of it we are representing both of you, some part of it we may be representing only you, the individual. But in any case, we are bound to maintain loyalty and equal confidentiality towards both clients. I haven't phrased that very well, but let me try it this way. lawyers have dual representation. Both parties, employer and employee, are equally our clients. So I cannot, uh, I cannot hurt one against the other. I cannot hurt one in favor of the other. Okay. Therefore, even if you inform them about what you're doing, which you should, because they should know what you're doing, it shouldn't hurt you in any way. If the lawyers are ethical, I assume all lawyers here are ethical, otherwise they'd lose their license to practice. I don't see why that should be a problem. Okay. So the bottom line is, because you're married to a US citizen, you should be okay. But you have another avenue, and that's the one that I don't think you've looked at. Your green card has been pending for 5 years. You can take a same or similar job using AC-21 also. So really, you are maintaining an I-485 under AC-21 also. What does AC-21 say? AC-21 says, okay, you can change, once your I-140 is approved, your 485 has been pending 180 days, you can take same or similar job anywhere in the country. Same or similar job as described in your labor certification. Now think about it. That means you can really move along and go anywhere you want as long as the jobs are same or similar. And we have a bunch of videos on those, a bunch of blog entries on those. Read through them, you'll understand these concepts a lot better. So really, there is almost no chance of you being in any kind of legal trouble, because AC-21 also doesn't say that you've got to maintain a job all the way. They only say, look, Mr. Individual, when the government, asks you, show me a job letter or an offer letter, at that point you'll have 6 to 8 weeks to produce such a letter that shows that you are either already working or you will be working for this employer who's offering you a same or similar job. So what if there is a little gap, 1 month, 2 months, even 5 years? As long as when I ask for it, you can produce such a letter, you're fine. See, this is just a 4-line question, but the answer had to be so long. I hope that makes it clear. Next question is Houston Krishna. Question regarding parents' green card in progress and travel to India for 3 months with advanced parole. So parents came to USA on a visitor's visa. It's been pending, the green card has been pending for 7 months. They came in June 2012. They've got an advanced parole document which is good till 2013 October. Mom's visa stamp, that doesn't matter, forget about that. They are planning to go to India for a short visit of 3 months and come back in August 2013, which is before the advanced parole expiration. Definitely they can travel. The only risk you are taking is there may be a gap if the green card is denied for any reason, which is very unusual and definitely not without an RFE. If it is denied for some reason, okay, something is so wrong that you don't even get an RFE, then if they are traveling back on advanced parole, at the airport, there may be a gap between their knowledge and the USCIS or CBP knowledge. So they could say at the airport that, Mom, Dad, sorry, you got to go back because your AP is no longer valid because your green card was denied. And even there, most CBP officers, I hope, are not so rude and heartless and inconsiderate that they will send older people who come after 22-hour plane ride back without even entering USA. They can be paroled into USA for a few days or a few weeks. Okay, but to apply for their green card again, you'll have to do it either through India or through consular processing, or you would have to have them come back in with a valid visa, which is more complicated. So probably consular processing is better. So again, maybe more information than you need, but unfortunately this is not an easy answer. So if they travel on parole, that's the only slight risk they are taking. I'm not that concerned about this risk. If it was my own parents, I wouldn't worry too much about it. Okay, because the trip is relatively short, 3-month trip, and I think they should be okay. One of the bullet points you've made is they have overstayed their 6 months visit. Not a problem, because before their I-94 expired, you had applied for their green card. I'm assuming I-130 and I-485 both. If you did not apply for their 485 at the same time, which I don't think is likely, then we need to talk. But if you applied for their 485, before their I-94 um, expired. And when I say apply, I mean the papers must have been received by USCIS before the I-94 expired. Okay. When they come back, even if my mom's visa is expired, is she allowed to enter USA? Definitely. There's no need to get stamped or anything because she's got the advanced parole. Is there something we can do safely to check the status of the application? You can contact your congressman's office, and we have a video on that as well, and see if they can find out for you what the status of the case is. It shouldn't be too difficult for them to do that. Excuse me, this just popped up. And by the way, if you go to immigration.com and do a search for member of Congress, you should pull up a video. Let's do a search. Okay, here it is. Yeah, here it is. The contacting members of Congress, etc. If you click on this video, it tells you how to contact your congressman. Okay, so you can do that. You can have them check the status of the case. Gentleman 84 says, I am on F1 status and faced severe economic hardship. I'm getting married, problems with the service. Fiance is a US citizen. Getting married. She's 41, I'm 29, and she doesn't work either. She's on food stamps. Well, first of all, when there is so much age difference and the woman is older than the man, these cases are always suspect. USCIS, call them whatever you would, old-fashioned or chauvinistic, but they always consider these to be red flags. So you're likely to be very closely grilled. Okay. On top of that, if she's not able to support you, she needs an affidavit of support. So some kind of a co-sponsor, etc., would be needed. It's not an easy situation. I don't think this is going to be an easy case to go through. Okay. Next question is PRPL GRL. Pending I-485 need help in getting back to the US. They left US unexpectedly while the 485 was pending, and while they were outside, their AOS, their advanced parole expired. Okay. The problem is when the advanced parole expires, your 485 is deemed to have been abandoned. Your 485 is deemed to have been abandoned. Can you salvage it? You can salvage your green card. That's not a problem because you can convert it to consular processing, or you can return on H1 or H4, whatever your preference is, or L1 or L2, whatever the availability is, and refile the I-485 and the PD becomes current. You can always refile. That's not a problem. Okay. So your green card is definitely going to be salvaged. Nothing to worry there. Just a matter of having to come back on another visa. Next question is Shahid Sharfi, applying for US citizenship with shoplifting, illegal residence, and diversion program issues. They are new to the forum. Well, welcome. Need some advice. Me and my family will be applying for citizenship in July. Here's what I'm worried about. I spent some time before 1997 in the US as an illegal alien. I went back, my brother applied for my residence, got immigrant visa. See, that's okay. That's okay. If you've already gotten your visa, I'm assuming that USCIS has gone over your status. Obviously, that's not a problem. The issue of illegal stay, can it come up during the interview? Unlikely, but if it does, just tell them the truth. Okay. N400 doesn't ask you that question. If it does, please check back with me in the conference about what the exact question is I cannot help you answer questions, but I can at least tell you if there's going to be a problem for you or not. There is no, to the best of my remembrance, there's nothing on the N400 form about illegal stay in the United States. So, by the way, if your wife and son have some problem, that has no bearing on your own on your own naturalization application. Okay. So your wife got a shoplifting citation in October 2010, but was not detained. Um, so you paid the fine. Okay. Now this is probably a misdemeanor. This is a lot more complicated question. I would want your wife to wait till probably November 2015, more than 5 years after the citation. Actually, after the conviction. So, whatever the conviction was, or whenever you pled guilty, I would say 5 years and a couple of months from there, then apply for her naturalization. It can become a problem, but at least there is a greater chance, much greater chance of success if you do that. Juvenile diversion program does not seem to be. Your son had a juvenile diversion issue because they got into an altercation in high school. It does not appear to be a big problem. This one should be okay, but if you want to be even more secure, you can wait until 5 years from the problem and then file for him. Okay, but your status should not be an issue. One more thing I want to add. I think it's better for you to get your naturalization first anyway. Because if something goes wrong with theirs, or they even try to come after their green card, the fact that a parent or a spouse is a US citizen could help you a lot. Okay? So get your naturalization out of the way. Your wife's is in 2015. And your son, if you can wait 5 years from the date of the diversion, that will be better. SCS 777 says, continue on H-1B or use EAD with current employer not having documents on labor / I-140. Namaste to you as well. I am with my current employer on H-1B. They filed green card under EB-2. I-485 was filed a year back. I'm assuming that your I-140 is already approved. Okay, you haven't mentioned that. If I lose my job and my employer cancels my H-1B, revokes I-140, so it's approved, without letting me know, can I use AC-21? Yes. Unfortunately, this is a common problem that employers have not given you copies of your labor certification, ETA 9089, or relevant documents that can help you protect your status. I find that quite odd, especially when you have lawyers involved. Like in Virginia, the bar expects us to provide you enough documents to protect yourself. We cannot favor the employer and get you hurt. Now, some employers occasionally ask us, well, if we don't want to give copy of I-140 approval to the employee, what do we do? We as lawyers have to get a waiver in writing from the employee saying, look, I understand that the law firm indirectly represents me as much as it represents my employer because I am the intended beneficiary of the application. However, I knowingly and fully, willingly waive all right to representation or to any benefit flowing from me from the law firm, flowing to me from the law firm. Something of that nature. So, excuse me. In many of these cases, I think the lawyers they should check with their bars. I had a recent case with a New York law firm. They refused to surrender. I asked them very nicely. I said, look, I've got a client here who used to be your client as well. And you are holding on to the I-140 and to the job description. I need for you to give me a copy of the job description so that I can file an AC-21 for him. And they just refused to cooperate. So I decided this was not acceptable. So what we did was we had our client file a Freedom of Information Act request for copies of the labor certification as well as copies of the I-140 paperwork. Many times in that paperwork you get everything you need. So that's another pointer. File a Freedom of Information Act request with both the Department of Labor as well as with USCIS for the I-140 and the ETA 9089 with the Department of Labor. So the law firm refused to cooperate. We were going to take some serious action against the law firm as well as the employer, but then 2 days later we got a call back from the law firm saying, not from the law firm, I'm sorry, let me rephrase that, from the employer, the old employer, saying that they were willing to provide the documentation. So sometimes, even lawyers don't take the trouble to understand what their ethical obligations are. It's a good idea to remind the lawyer that, no matter who paid your fees, you represent both of us, and you are under an obligation to give me sufficient information to protect myself. Okay. If I lose my job and employer cancels my H-1B, revokes I-140 without letting me know, can I use AC-21? Almost certainly. As long as you find out about that, and you will make sure your address with the government is updated. Will it be good to switch to EAD now? That doesn't matter. That doesn't matter. Don't worry about that. You can switch to EAD anytime. My employer didn't share labor cert, etc. with me. Can I change employers if I switch to EAD now? You should get the Freedom of Information Act request filed. If I change my job, my current employer will definitely revoke I-140. Make sure you file the AC-21 letter. It's no issue. Does your office handle such cases? Sure. We'll be happy to assist you. You can send us an email directly to me, help@immigration.com, or you can just go to the immigration.com webpage and send, let me show you where the contact information is. So if you go to immigration.com, right on top, oh, I can't get this. Let me see if I can get this document in view. But the top bar has an entry for contact us. Okay, let's see. Yeah, now you can see it. You see that right here? Contact us. You can write to us from that place. Okay. So going back to our discussion, Yemi received 10-year green card in November 2012 with the wrong residency date. So they tried to correct the residency date. In the meantime, they applied for their naturalization. So the question is, I've been told that I'll be asked to turn in my 10-year green card, but I have not received my replacement back yet. No problem. Because you applied for naturalization, that's fine. USCIS should not create a problem about that. And they often will. They may not have issued you the replacement because you applied for naturalization. It's not a big problem. Don't worry about it so much. Okay. Remember, when you surrender your green card, you'll probably have your naturalization certificate at the same time. So it should be okay. So best option to bring spouse from India for US citizens. See, if you get married, the only real option you have is file for I-130 and K3 together. So if the I-130 green card comes first, she comes on that. If K3 comes first, she comes on K3. So I-130 K3 combo. Okay. And once she comes in, she'll come in with either a green card which allows her to work, or a K3 which also allows her to work. So it should be okay. Okay. Oh, by the way, the turnaround time is not that great, Abe. It can take a few months, 6, 7, 8 months, maybe more. Question on I-693. So what happened with Ish-AT is this. The son needs a vaccination. The question is, should we wait for an RFE on the pending I-485 before we get the child vaccinated, or should we get the child vaccinated now? You can go either way, because I know you're concerned that if the RFE comes and we could again get stuck if there's a retrogression while we are responding to the RFE. Of course, that's always a possibility. Okay, but Typically, in family-based cases, it's not that much fluctuation. I don't want to say it's never like that. So it doesn't look like a very major risk even if you waited for RFE. The way I look at it is very pragmatic. If the vaccination helps the child, get it now. What is the harm? Okay. And submit it to USCIS. You have the A number. It should be okay. That's the way I would do it. But if you want to wait, even then I think it's okay. It is not a big risk in my opinion. Okay. Next question is Sarla 786. There's a TVU, Tri-Valley University issue here. You had applied for OPT last year. You got an RFE. And the lawyer said, oh, withdraw the OPT application. In my view, it's uniformly a bad idea to withdraw when you get an RFE, because I think it red flags you. Okay? You should respond to the RFE. You know what we do? If we are going to withdraw a case, we make sure that there's sufficient reason explained to the government for withdrawal so they don't think that we are running away from the case. Okay? So no, I don't think you did the right thing. In my opinion, it was not good advice. Almost always, I prefer to respond to the RFE and deal with the facts as they are, instead of trying to get away from them. How many applications did they receive for H1 this year? 160 some? It's public knowledge. Are they planning to increase the quota? Well, increasing the quota is not that easy. It will take action from Congress because Congress set the quota. And Congress is only going to do immigration reform in a comprehensive way. I don't think they are going to do piecemeal increase. But I'm not an astrologer. I can only say what I feel is going to happen. I don't think quota increase is likely. Now you've got an RFE for an H1. Look, we've done a bunch of these and we've been successful in some and not successful in some. Typically, where the student was acting in good faith and they were not trying to take advantage of the system, even if they were on CPT, but they were attending all their classes and they did the best they could to maintain status, we were able to get the status restored. Okay. I don't know what your background is, but as long as you did everything by the book, at least you have a good chance of getting status within USA. Okay. Also, there is another aspect. What is the worst case scenario? Well, worst case scenario can be a lot worse, but let's say what is the normal worst case scenario? If USCIS says you're out of status, they can make you go outside for a visa stamping. Then you are at the same level of risk as everybody else for a visa stamping. Just because you were a TVU student does not increase your level of risk in getting the H1 visa stamping unless you were involved in some kind of active fraud. I'm yet to meet any TVU student who was actually involved in any kind of active fraud or referral fees, etc. Okay, so you should be okay. Respond to the RFE the best you can, and if you have to go, then you have to go outside USA. Jazz has gone back. She has a green card. She's gone back with a re-entry permit. She had an injury. The re-entry permit is expiring in July 2013. She has a 3-year-old son, and husband got deployed to Afghanistan as a contractor with the US government. So the 3 questions. Can I get with the US Embassy Council and show them the paperwork, doctor's contact, so they will extend my stay here? They cannot. Advanced parole or re-entry permits cannot be extended outside USA so far. 2. Can I turn in my green card and reapply? Yes, you can. If your husband is a US citizen, that's easy enough. Number 3, will I get banned if I don't make it back? Well, there is no ban, but you would lose your green card you can try to get the same green card back through a process called returning resident permit, or S as in Sam, B as in boy 1, Arabic numeral 1, SB1 visa. Same thing. You go to the consulate and you say, I want to apply for an SB1 visa. They will ask you for an explanation of almost every day that you were outside USA, why you were late in coming back. And if you have a good medical reason, I in fact had a case like that um, a few years ago. We don't get the situation very often, but we were able to get the SB1 fairly easily because there was a genuine problem. There was a medical issue. So if there is a good reason, you should be able to get your SB1 and use that to come back to USA. You can of course surrender your green card and get a new one again. But then you have to start your citizenship period all over again. Okay. And if you're all right with that, married to a US citizen is only 3 years anyway, so it should be okay. Abhay 1266. EAD since 2007. Wife has her own H1B. You have changed employers. 2 different questions. Not filed AC-21 every time I switched my employer. What should I do about it? Nothing. There is no law that says you have to file an AC-21 letter with the government each time. I think it's a good idea. You can start at any point of time. You can start an AC-21 letter now, even though you switched 7 employers. Where do I find accurate information about filing AC-21? Get yourself a lawyer. Do not try it yourself. By the way, our blogs have a lot of information about AC-21, almost, I would say, 40, 50 pages, including videos on AC-21. Okay, so go to my blog. I also want to start a company with my wife as owner, and I want to work under that company full time. She's on EAD as well. Well, doing an AC-21 for a company owned by your own wife is certainly possible, Abhay. Is it advisable? I would be cautious about that because it's an untested approach. I know lots of people who did this and had no problem. Okay, but because it's still untested, government has never challenged it, we have never won something like this, I'm a little reluctant. And if you look at the Yates memorandum that started and explained this AC-21 law, there's no regulation, as you might know. There is only memoranda. And the most pivotal memorandum is a memorandum from Bill Yates in May 2005, when he was asked the question, can I do AC-21 portability to my own company? And they said, that's not forbidden. He didn't say it's allowed. He didn't say that's not, he said that's not forbidden. So it's like a double negative, something like that, he said. Okay, that makes me cautious. What does that mean? It's not forbidden. One thing that I see quite often is this. Let's say you are a technical person. Your green card was filed as a technical person. If you start running your own company, your job description changes. You become a CEO or a manager. However, if your wife is managing the company and you are just an employee, you can be owner, but you can't be changing your job description. See, being an owner in a company is a matter of owning stock. That doesn't define your job. Your job should remain the same. I am not that comfortable with this scenario, but if you are a risk taker and you say, Rajiv, I'm willing to take a risk, go for it. I think you'll be protected, but again, I have to be cautious for you. Prince C. Premdas says there's a clerical mistake in my MCA, which is Master of Computer Applications certificate. The old certificate and the new certificate has been correct. Well, the new certificate was corrected by hand. Problem is, for the H1B, they sent in their old uncorrected certificate. So the new one is corrected but hand corrected. I think that's a bad way to do it. And the old one is wrong. Is there a problem with this? I certainly don't like it. Okay. That makes me uncomfortable. I think this should be corrected. I even feel that maybe the H1 should be sent in for an amendment. Okay, I don't think it should be allowed to stand like that. Ish Sethi, this appears to be a duplicate post about the child's immunization. We've dealt with this issue already. Next one is Uday01. Oh, this is a long one. Company A filed EB3 and I invoked AC21, joined Company B. So A to B on AC21. Company C applied for EB2. I-140 got approved. Priority date as August 2004. Then the company went out of business. Now I got an RFE stating as below, which needs to be answered by May 27th. Current company is reluctant to give anything related to EB2 because the EB2 company is out of business. Okay. So what they are saying is the RFE that you've received says if you want to convert your I-485, which has been pending under EB3, to EB2, you must make that request in writing. My problem is, I would find it, if I were the lawyer on the case, I would probably find it unethical to try to revive an EB2 case which is based upon a company that went out of business, because that I think is just inappropriate, if not illegal. It's a very difficult issue of law. So I kind of concur with your Company B that it's difficult to give anything about Company C because they're already out of business. So doing any kind of AC21 or conversion based upon an I-140. Now, if you had done it earlier, I would have been okay with it, while the company was still in business, Company C. Okay. So, and also remember, I-485 is your application. If you want to do something aggressive with your application, that's your choice. Really, you don't need your Company B to give you any permission or conversion. It's not their request for the conversion. Okay. My advice is walk away from it. Do an EB2 with somebody else if you have to, but don't use this EB2. You could get into trouble. Baldwin, H4 to F1. I'm on H4. I will age out in 2 years. I want to change to my F1. But my parents' 485 was denied a year ago, and a second I-140 approved. Since I was included in my parents' 485 and I-140, will I have any problems changing to F1? We have a lot of cases like this, and usually government is quite understanding. Technically, they shouldn't be giving you the F1. But I know a lot of cases, I've seen a lot of cases where they gave F1s in situations like yours. Worth trying. DVS cab, H1B stamping. Went for H1B stamping at Mumbai on 9th April. Got a 221G, cancelled without prejudice the H4, and asked to submit documents. And then also the verification that the employer will provide employment. My H4 is cancelled without prejudice. Can I apply for H4 again? Yes, you can. So will there be a problem for getting H4 approval again? That I cannot predict, but you certainly have the legal right to do so. After Visa Office asked me about my employer, I got doubt if I submit all the documents whether it will be approved or not. Look, I think you should follow it through. I think you should certainly follow it through. See what happens. Okay. If the employer refuses to cooperate, let the Visa Office know that you tried and the employer doesn't want to give the documentation. Okay. Third, I got very good job offer in India with a very big MNC, I guess that means multinational company. And they promised me that they will transfer my H1B new petition under cap exemption if I work for them at least 3 months offshore. Will 221G affect this? Yes, I think it's a good idea. Well, let me rephrase that. If the 221G is totally directed towards the company, I still think you should try to respond with the company's help, the old employer's help. But if the old employer does not wish to help, you should make some kind of a representation to the visa office saying you need to withdraw this application because the employer is unwilling or unable to supply the documentation. And then it should not become a problem in the future. If you just run away from it, it could potentially become a problem. If, on the other hand, the 221G is directed not only to the employer but also to you or only to you, for example, some certificates are needed, some mark sheets are needed, then you must supply those, otherwise you'll always have a problem. Okay, so try to take that job up, the one that has been offered to you. In the meantime, try to supply the documentation asked by the visa office. If they don't give you, employer doesn't give you the documentation, withdraw your application. You should be fine. DSM 918. Last year of H1B expires September 1st, 2030. They haven't still started the perm. It's not been filed yet. Okay, but you do have a backup in the form of an EAD through your wife, and you can go on that EAD. Company has said that they'll continue the green card process, and once the perm gets approved, and you need to go back on H1B, you'll have to leave the country and reapply for the H1B. That's true. If you're on EAD, you have to go get a visa stamp and come back in to reactivate your H1B. So you have some confusion about how this whole thing works, the extension beyond 6 years of the H1. Well, here's how it works. There are two sections of law, AC21, that permit you to get extension beyond 6 years. I think it's 104 and 106 or 204 and 206 sections of AC21. The 04 deals with 3-year extensions, 06 deals with 1-year extensions. And how does that work? One is tied into the amount of time your case has been pending, and the other one is tied into the stage. So let's talk about the stage-based case. That's the easy one. If your I-140 is approved, POM approved, then I-140 approved, we don't care what stage, how long your case was pending, we'll give you 3-year H1 extensions indefinitely. So only thing we are concerned about is the stage. I-140 approved, you're good to go. The second method is to get 1-year extensions. The H1 1-year extensions are given to those people whose PERM was filed a year ago. Whether it is pending, approved in I-140 filed and pending, or denied and in appeal. In all of those three cases, once that 1-year anniversary is reached, you start getting your H1 extensions beyond 6 years. So two ways: I-140 approved, 3-year extensions; Labor Cert filed a year ago, 1-year extension. Okay. I saw that was one of the confusions you had. If my PERM is applied before the H1B expiration, I will have to go on EAD, sure. Once it gets approved after I've gone on EAD and I want to go back to H1B, am I required to wait 1 year outside the country? No, because you're not subject to the quota. Quota is not an issue. Exhaustion of 6 years is the issue. So even if you're on EAD and either the I-140 gets approved, in which case you get 3-year H1, or PERM has been filed for 1 year, you get 1-year H1, quota is not an issue. You go outside USA, get your visa stamp. How difficult that is, we don't know. Get your visa stamping and come back. Okay. Am I better off just sticking it out on my EAD and not try to go back on the H1B? Well, that depends. if the visa stamping is going to be difficult in your case, I don't know your case, then I would just stick with the EAD. I prefer having an H1 because it gives me more options in terms of if 485 goes bad or something. Even if she gets laid off, she will not be out of status because her 485 had been pending more than 180 days. Good. I-140 approved for your wife. Her 485 pending more than 180 days, she's fine. What happens if she's unable to find another job till the priority date becomes current? That could be problematic. She should have a similar job as soon as the green card date approaches. I think that's important. So two-part scenarios. If two-part question based on two scenarios. If the priority date is still not current by March 2015 and she has a new similar job, how can she extend her EAD beyond March 2015 if she's no longer with the sponsoring employer? That's fine. Can the new employer extend it? No, it's not the employer who extends it. It's you guys who do it because it's your case. Okay. The idea of AC-21 is that you are not going to be with the same employer. You're going to some other employer. So therefore, of course, she can extend her EAD, no problem. Okay. If the priority date is still not current by March 2015 and she does not have a job and the EAD is expiring, how can she extend her EAD? She can extend her EAD even without a job. That's not a problem. AC-21 allows you to do that. But if USCIS sends her an RFE, provide an offer letter or show that you're working in the same or similar job, then you have a few weeks to provide that. At that point, you don't have a choice. But if in the meantime, for a year, 2 years, she doesn't have a job, no problem. Excuse me. I think I'm running out of steam here. Application for OCI card. Don't know anything about OCI cards. Sorry. Indian side, I cannot help you. I practice law in USA. I-485 help. My daughter, who's 14, received a fingerprinting notice for her pending 485. Next thing is they get an update saying 485 has been approved. But the primary has not been approved. So they've approved the derivative without approving the primary. I mean, this is an error. They do it all the time. I think you should call USCIS customer service, let them know. They'll probably send you a follow-up letter saying, oh no, we did this in error. And that way everything will be corrected. Okay. So no, this needs to be corrected in my opinion. Consultant 007. Notice of intent to revoke. Oh, don't even get me started. We have seen cases and we are dealing with cases where notices of intent to revoke are sent after 6 years of I-140 approval. Okay. And your question is, will I be able to keep the priority date if something happens? No. If the I-140 is revoked, we don't keep anything. That will be, I mean, of course, I've argued cases like this and I've said it was approvable when filed and that's all that matters. But it becomes a very long shot. Okay. So I don't know how serious the notice of intent to revoke is. If it is something minor, I think it'll be okay. But you still, you may not be able to use that for priority date or for AC-21. May not, because it's a very delicate issue. I've gotten some very strange situations with the USCIS. Some of them I would have said they're not even legal what USCIS has done, but they've done it. And if they are in my favor, who am I to argue with them? In some situations, they've done illegal things. Of course, there we have advised clients to file lawsuits against the government. But it's just this whole area of NOIR, unrestricted, unfettered, unchained power, is absolutely a disaster. USCIS has done so much harm to any degree of certainty with notices of intent to revoke after years and years of pendency. There's a decision, if I remember, was it from Seattle? I think it was from Seattle, where the court said, how can you send a notice of intent to revoke 5 years later and say, produce X, Y, Z documents? Employee has moved on. They've done AC-21. They're not even with the same company. What incentive does the old company have of providing all these documentation? And that's a very good observation. And of course, in that case, I think that, I don't remember if the case was won or not. It's a recent case. But it was a very strong observation from the government. And they against the government, court used some very strong language against the government. And I think more courts should do that. This is absolutely ridiculous. I agree that they have the right to revoke, but it should be only used very sparingly in very extreme cases where there's a lot of fraud involved or something. It's just nonsense what these folks are doing. But that's what we are dealing with. I'm willing to take your legal advice and representation. Well, I don't know what the problem is. I don't know if I can help. Would be happy to give you a consultation and go over your paperwork. And I'm going to argue that you should be able to keep your priority date, and you've used your AC-21 in good faith. The case was approvable when filed. And that's the most important thing. That's what I would argue. And we have a whole slew of things that we say in support of these contentions. But can I save it? I do not know that. I really do not. And ideally, it should be really your employer against whom the I-140 NOIR has been issued who should be hiring us, not you. Because you have no standing, so to speak. Courts have said you have standing, but USCIS says, no, you don't have standing. You can't really provide responses. And we've done this as well. Company is defunct. They are no longer in existence. So we say, what do you want us to do? We're going to respond on behalf of the employee. Again, very inconsistent, very murky area of the law. Not a good place to be. Okay. Singh SS says, claiming my unused time for H-1B. Here is the situation. I was waiting for a decision on my visa transfer from L1 to H-1B starting October 31st till December 7th. I wasn't working. Can I claim this back? Well, it's again, very gray area of the law. Go for it. Try it. You may not get it, but it's worth trying. Folks, that's pretty much all I have to say today. I want to point out a couple of things to you. For the new laws, we are actually gearing up, and we're still not quite done with it, still preparing a way to present the information to you in the best manner possible. So if you go to our forums, you see this is a new area that we have just put in today. Comprehensive Immigration Reform 2013. You go in here, there are 3 sub-forums. One talks about information and discussion. This is where we can discuss things. And we have links to what we are doing, how we are presenting you information. And then there are 2 other forums. There's about 27 people looking at this right now. Media News, where every 30 minutes we are presenting you news about, from media about immigration reform. And then we actually select, most of this I do myself, I select those items of news that I think are very, very important. So 3 forums, information and discussion, news from the media, and selected news. And then on immigration.com side, if you look at the resources link, it tells you that we are actually preparing on immigration.com side, we've prepared a page for comprehensive immigration reform. We're still working on it. It should be ready by tomorrow. Okay, so you'll have more information here about policy, how bills become law, things like that. Just thought I'll point this out to you. Thank you for your time, folks. I will post this, and I'll ask Monica if we should just open a forum for follow-up questions. We'll have another call to make up for this one we couldn't do live. Bye-bye.